Hey everybody, Attorney Lacey Thompson from our Columbia office. If you hear something in the background, I had to bring my son to work today. But today, P. Diddy is being sentenced, and it's a little different from state court, so I thought I'd jump on and kind of explain that. So we all know that he was found guilty by a jury, a couple months ago, and now he has been sentenced today. And that's how it works in federal court. We don't do federal work, we just do state court, and it's vastly different. So in our procedures, once someone is found guilty, and that's by a jury or by pleading guilty, they immediately go into the sentencing phase. So you plead or you're found guilty, and then you'll immediately be sentenced by the judge on that case. So let's take a plea, for example. If someone pleads guilty to a crime, oftentimes there's a recommendation by the prosecutor, and the reason for that is the prosecutor knows the full picture of the story. So oftentimes there is they're making a recommendation to the judge as to what they believe the sentencing should be, whether that's probation, active time, it could be split between those things. And typically a judge will go along with a recommendation. There are times that they don't, and they're not required to, but typically they do, because they understand that this was, something that attorneys talk to about it, positives of the case, negatives of the case, mitigation, concerns. So oftentimes they do go along with the recommendation, because it's typically coming from two lawyers, and most of the time defense attorneys ask to accept that recommendation, because usually that recommendation is coming from both parties coming to the table, sitting down, laying everything out there, and trying to find an appropriate resolution in the case. Sometimes though there's not a recommendation, and we call that a straight sentencing. So basically a person pleads guilty and it's straight up. They could get the minimum, they could get probation, they could get the maximum, multiple years in prison, and it's up to the judge. So once someone pleads guilty, the state reads the facts of the case, and at that point somebody can speak if it's a victim crime. The victims have to be notified of the date. They don't have to come, but they do have to be notified to comply with the Victim's Bill of Rights. And then they get an opportunity to speak if they want to. And then at that point, once the state closes kind of their presentation of the plea, it turns to the defense. The defense will then present mitigation. So some of those things about mitigation could be being out on bond and not having any rearrest, having a job, a family, children that they're supporting financially. They also can have witnesses speak to mitigate the case to the judge. So that's how it works in state court. For a trial, it's very similarly done, except you don't have the facts, because the judge has clearly heard everything throughout a trial, so that portion is skipped over. So what will happen if someone is found guilty at a jury trial, then the state will present the defendant's record. So if they have a rap sheet, prior crimes, convictions, they will present that to the judge, and then again let their witnesses speak to the judge if they want to, and then it flips back over to the defense, and it's the same thing. They can present mitigating circumstances and situations and stuff of that nature. So like I said, federal court is very different. As you can see, that this is a delayed sentencing. In my opinion, it's delayed. In federal court, this is normal. This is the standard process for how they do things. You can see where they're arguing about certain facts to make it certain levels, because in federal court there's sentencing guidelines. There's guidelines that the judges are supposed to go by, and within those guidelines they sentence. It's not that way in state court. In state court it is a free-for-all. I mean, we have a charge that carries 0 to 20 years. So if it's a straight-up plea, you could get probation, you could get 20 years incarceration, and there's no guidelines. It's truly just up to the judge in front of you in that situation. So it's vastly different in federal, like I said, because you do have those guidelines, and from my understanding of it, certain things can bring you down levels, and so that's kind of what the prosecutor and defense attorney are arguing about now, because clearly the defense is trying to bring those levels down to bring the guidelines down for sentencing, so the judge can't sentence even more jail time. So that's just a little overview of sentencing and pleas and how things work and are a little different between federal and state. So if you have a state charge and you've been charged here in South Carolina and you have questions, please give us a call.